So let me begin by saying something about the politics of this liberal legalist orthodoxy that Kamari talked about in her presentation. I want to give a sense of where does this orthodoxy come from? How does it understand itself, and what has it done in this region? I wrote this book a few years ago called Distant Justice, which was about the work of the International Criminal Court in Uganda and the DRC. And it was a book that focused on the ICC, but actually it was a book that was mainly inspired by an interview that I did at the ICTR in Arusha, way back in the mists of time when I was a PhD student. I turned up to the tribunal, very green, very naive, understanding very little. Arguably, I haven't understood much more as time has gone on, but I was really, really unclear in those days. And I got an interview with a senior ICTR judge, and I had read the ICTR statute, which said that the reason that the ICTR was prosecuting high-level genocide suspects from Rwanda was that ultimately the tribunal would contribute to the pursuit of national reconciliation in Rwanda. So I said to this senior judge, it says this in your statute, that you're not just doing justice for its own sake, you're doing it because you think that this helps the pursuit of reconciliation. So what fruits of your labors have you seen on the ground in Rwanda? Can you tell me how the work of the tribunal has played out in the places where genocide crimes were committed in '94? This judge looked at me like I was a space alien, contemptuous, and he said, I've never been to Rwanda. He'd been at the tribunal for about 10 years. He says, I've never been to Rwanda, and I have no intention of ever going there. Because if I went to Rwanda, I would develop an emotional attachment to people and to the place, and it would undermine my role as a judge at the ICTR. I was kind of flummoxed by this. I didn't really know what to do with it. It troubled me, it puzzled me, that comment, and I heard similar things from lots of other senior ICTR people on that visit. It struck me as a very peculiar idea of justice needing to be detached, of needing to be insulated. I mean, my kind of crass recollection at the time was that you wouldn't buy a used car like this. You wouldn't do your grocery shopping. That the less you knew about the thing, the more wise it would make you in the decision-making process. It struck me as a bizarre reaction to prosecuting something as profound as genocide crimes. So it's kind of stayed with me. Fast forward a few years, I wrote up my PhD thesis into a book on Gacaca. I got married. Some of you around the table know my wife, Nikki Palmer, who's gutted that she can't be here this week, but she's going to present online as the week goes on. Nikki then produced her book, Courts in Conflict, looking at the relations between the ICTR, the national courts, and Gacaca. And she, I think, started to help me deal with that conundrum that I had had in my own research, trying to fathom this judge's comment. And one of her big findings, based on ethnographic work inside the ICTR, was that ICTR judges and lawyers, for the most part, defined themselves in opposition to the work of the Rwandan national courts and Gacaca. One of the lawyers that she quotes in Arusha said that Gacaca was just people sitting under trees talking, which on one level was true. Gacaca was often, in various communities around Rwanda, about people sitting under trees talking about the crimes and the events that they had lived through. But of course it was much more than that. But what Nikki found in her book, and I think she'll talk about this a little bit more as the week goes on, was that ICTR personnel were making sense of their own work in opposition to these domestic institutions. They were thinking about local spaces in particular ways that supported their own sense of self-worth. So then when I came to write the book on the ICC, I had these thoughts kind of percolating. And what I ended up isolating in the book, trying to make sense of that interview that I'd had many years before, and this was in the context of the ICC, but it really resonated from my research on the ICTR, was that there was an idea of distance that was at the heart, not just of the ICC, but of all international criminal legal institutions. And that in many respects, that helped me understand that comment from the judge many, many years prior. And so in the book, I tried to unpack in theoretical terms what this idea of distance was. So what I want to do now, in a few minutes, is just sketch for you the main components of this distance idea. And then I want to show why it's been so problematic in the Great Lakes. As the ICC and the ICTR have enacted this idea of distant justice, why has it played out in such damaging ways for this region? So there are various components to the idea of distance. Let me sketch it for you. The most obvious one is geographical. International criminal law institutions are based geographically afar from the places where crimes were committed. They're based in The Hague, they're based in Arusha. There's a profound sense of here and over there. We could talk a lot about issues of place and space. Maybe we can pick that up in the discussion, Tom. I don't want to get into it too much here. But embedded in the way that these institutions play out, there is a very clear geographical distinction. Now, that geographical distinction is important for more profound reasons. One is that distance also in the work of the ICC, the ICTR, and other institutions carries with it a self-perception of these actors as neutral, as impartial, and as hovering above the political fray. These courts, these tribunals see themselves as superior in their judgment and their decision-making. We are impartial, we are neutral, as opposed to those domestic bodies that are beholden to political calculations, that are corrupt, that are under-resourced. So that idea of neutrality is absolutely central to this idea of distance. It also carries with it an idea that justice is best delivered by personnel who are heavily detached from the atrocity context, as represented by that ICTR judge's comment. Basically, you can't trust the locals, to put it more bluntly. What you need is people who are not embedded in the crimes or the contexts that we're talking about, but have this more enlightened detachment to be able to see things objectively in a way that local actors cannot. One of the ways that that's played out in practical terms with the ICC is, and Tice and others have written a lot on this, is the stipulation both by the ICC Prosecutor's Office and by the defense that their investigators spend incredibly limited time in the field conducting investigations. For a long time, the ICC Office of the Prosecutor had a policy that their investigators were to spend no more than 10 days at a time in any place. The idea being that if you spent too long, you would go native. You would become vulnerable to manipulation and corruption. You might get too close to your subject matter. So get in, get the evidence, get out. In places that these investigators, by their own admission, had never been to before. So distance was important. Again, it connects to this idea of neutrality. Distance also carries with it an idea that justice is ultimately about the law, following the rules, rather than calculating the consequences of the law. It's a very important component of distance. Justice means following the statute. It means following the law wherever it takes you. And the calculation of what impact that might have on the ground is counter to justice. It's a very important component of the distance concept. Distance also with the ICC and the ICTR and other institutions, and I think this is where, as a political scientist, I start to get quite excited because it gets me into discussions about power. Distance carries with it an idea that we need international criminal law to improve state behavior. International criminal law is profoundly skeptical of state power. That power is assumed to permeate the entire domestic arena, and therefore, because of distance, international criminal law is skeptical of the local space because it's seen as being controlled. It's seen as being manipulated. It's seen as being politicized. Whereas the international, again, is assumed to be above all of that. It separates itself. It insulates itself from those political machinations. What is important in that component of distance is that we see at the heart of international criminal law a profound skepticism of the local generally. Domestic courts, domestic governments, sometimes even local communities. It's right there at the heart of institutions like the ICC and the ICTR. And why is that important? Because that's not how the ICC and the ICTR talk about their relations with domestic actors. They have a totally different set of terms. The ICC talks about complementarity. The ICTR talked about concurrence, all of which carries with it an idea of respect for the domestic space, partnership with local actors. To put it very bluntly, it's bullshit. They say it, but they don't mean it. What we see, in fact, manifest in the practices of international criminal law is this philosophy of distance at play and the skepticism of the local. And in fact, if you go back to the early debates about the Rome Statute underpinning the ICC, it's all the way through the negotiations in Rome. The language is always about the failure of domestic institutions to deal with crimes in particular places, the inability, the lack of resource, the lack of technical expertise in the domestic space that necessitated the creation of the ICC to begin with. So the skepticism of the domestic is there from day one. And yet the language is complementarity, sharing the space with these actors, when in fact these institutions don't like the local at all. So that's distance in a nutshell. It's got all of these various components. It's geographical, it's philosophical, it's technical, it's practical, it's relational, vis-a-vis domestic institutions and domestic actors. So why does that matter? Why does distant justice matter? Why should it hopefully help us in our pursuit of rethinking new futures of justice? It's been important in the Great Lakes region for three reasons, or at least three main reasons. And I'm going to end on this. I think distant justice through the ICC and the ICTR in particular have produced three major problems for the states and the societies of this region, but this hopefully will resonate far beyond the Great Lakes. The first problem is distant justice has produced a mentality within the ICTR and the ICC that basically says justice has to look like us. What this philosophy and practice of international criminal law has done is to constrain attempts in this region to deploy post-atrocity responses that do not comport with international liberal legal ideas of what is acceptable and what isn't. What's interesting, even in the way that complementarity is represented in the Rome Statute, it's kind of a classic liberal move. It sounds very tolerant. The language is around the primacy of domestic institutions, the importance of domestic rule of law efforts. But if we dig down into the way the ICC has enacted complementarity, what we see is domestic institutions are tolerated as long as they look like the ICC. As long as it's a particular model of criminal trial, typically with imprisonment as the core form of sentencing, domestic institutions in this region, the view says, are allowed to do what they want as long as they don't get too funky, as long as they don't sprawl outside the orthodox view of what an acceptable form of justice is supposed to look like. So as a result, what we get is a homogenizing process. International criminal law wants everything to look the same. It wants to see mini versions of itself enacted in parts of Africa, for example. We can live with that. We can live with the domestic, that view says, as long as it reflects our own views of what justice is supposed to look like. And what this has led to in this region is the undermining of national sovereignty. A couple of you mentioned sovereignty in your personal introductions yesterday and today. It's a crucial issue in this domain, in this space, in this region. If we want to talk about international criminal law, we've got to talk about national sovereignty. It's heavily charged, this issue of sovereignty, especially in post-colonial states that have a long history of fraught interactions with external actors. Not just during the colonial period, but thereafter. These are states and societies very, very sensitive about being told what to do. And ICL, transitional justice, has stumbled into these very loaded historical spaces, often without an understanding of the past. an understanding of the minefield that they're walking into, and with a real insensitivity towards concerns around sovereignty. And so what we get in this idea that justice must look like us, which I argue is a symptom of distance, is a constraint on actors to think creatively and to act creatively in response to mass atrocity. The options now are narrower than they used to be. The decision-making terrain has become much more constrained and less interesting than it was 20, 25 years ago. Let me give a couple of examples of how this has played out in the Great Lakes. We've talked a bit about Gacaca. Oh my goodness. I mean, and my Rwandan colleagues here will remember this period, I'm sure, if you're old enough. Some of you probably weren't, but some of you are. When Gacaca was first proposed in the late 1990s and the early 2000s, as the key way that Rwanda was going to prosecute hundreds of thousands of genocide cases, the international community went berserk. And not even in a very polite, human rightsy kind of way, like genuinely berserk. Amnesty International, Human Rights Watch, the ICTR, various UN agencies putting out press releases and communiques, denouncing the idea that it was legitimate to prosecute genocide cases with everyday judges who could not be professionally legally trained. The idea that Gacaca was going to prosecute not just senior suspected perpetrators, but everyday actors. Your peasant farmer on the hill who wielded a machete in 1994 would be fair game for prosecution. That this would involve these very open, messy, communal dialogues about the past in the process of Gacaca trials. And that the sentencing might not necessarily involve prison terms. It might involve commuting of sentences, community service. All of this was red rag to a bull for the international liberal orthodoxy, which came crashing down on Rwanda at the time. Donors threatening to pull their funding, moral claims being made by international lawyers. Interestingly, this also came with vociferous critique from Rwandan lawyers. It wasn't just international actors. Many Rwandan jurists, the Kigali Bar Association included, said that this was a bad idea. There's no way known you should give lay people the job of dealing with genocide crimes. So that's important because it says that this isn't just about international actors being concerned about local creativity, it's about the law. It's about lawyers. Many of you are lawyers. I'm not, so. But I'm married to one. And I live with you people. And I love you dearly, I do. You may not think that by the end of this talk, but I do. I love lawyers. Sometimes. Under certain conditions. So it's interesting that Rwandan lawyers were some of the sort of most vocal critics about all of this. But these critics, when you threw it back to them and said, okay, so you don't like Gacaca, you don't think it's a good way of doing post-genocide justice, well, what else are you going to do? Tell me your alternative. When you asked that question of the critics, you got two responses. The dominant one was absolute silence, because they didn't have an answer. The second one, over time, was you should just give an amnesty to these low-level perpetrators. It's interesting. You go to the hills. So end of this week, I'll be sneaking out of the summer school. Confession time, right? Because I'm going back down to the Bugesera in southern Rwanda. So I've got a group of genocide perpetrators that I've interviewed every year for 20 years. Because they live side by side with the genocide survivors attached to their own crimes. And I go there every year to see the situation, how are community relations going. And really, in many respects, it's a continued longitudinal study looking at the long-term impact of Gacaca. If even the convicted perpetrators themselves say, we needed Gacaca to enable us to go back to the hills. If you had just let us out of prison in the late 90s, early 2000s, and sent us back to our villages with no intervening process whatsoever, we would have faced lynch mobs on the hill. It would have been an absolute bloodbath. So this amnesty prescription, which some international lawyers concocted in the early 2000s, simply wasn't contextual. It wasn't fit for purpose here. They were influenced by the South African experience and others, but it paid no attention to the real life consequences for dealing with genocide crimes in a place like Rwanda. It would have been disastrous. The other thing that the critics underestimated in criticising Gacaca, and this is where I'm going to be an Australian interpreting things that Rwandans said to me. No Rwandan I've ever spoken to has used this language, but I will. They underestimated this Rwandan government, the RPF-dominated government's fuck you attitude to the international community. Totally misunderstood or failed to grapple with the politics of this place. You have a government that listened to all of these criticisms and then said, thanks very much, we're going to do what we want anyway. Because who are you to tell us what to do? It's deeply embedded in the RPF as the ruling party, many of whose senior members grew up in refugee exile, have a deep sense of resilience and self-reliance. And on top of that, a real sense of being abandoned by the international community during the genocide. So who are you to turn around 7, 8 years later and tell us how to do justice? Where were you when people were being killed in 1994? So the critics weighed in with no appreciation of these very important local political dynamics. And was it any surprise then that their prescriptions were completely ignored? So they tell you justice has to look like us, but this is the reaction to that particular viewpoint in Rwanda over the last 20 years or so. I was going to say something about Uganda, but I'm worried about the time. So let me move to my second problem that comes from distance, and I will say something about Uganda on this point. The second viewpoint, in practical terms, that has come out in this region as a result of distant justice is the ICC and the ICTR saying, we will intervene when we wish, so you better get out of the way. As I said, complementarity and concurrence sound like a recipe for partnership with a deep respect for domestic institutions. Don't be beguiled by that. Don't be beguiled by that language, because it's not how these things are played out in practice. What has tended to happen, and in fact it's built into the Rome Statute, is that international actors in fact get the first bite of the cherry. They get to decide which criminal cases they will or won't deal with. It's similar to the principle of the responsibility to protect. It's the responsibility of domestic actors to do X, Y, and Z, but guess who gets to decide whether domestic actors have done that or not? It's the international level. So the international level says, let's just wait and see what the domestics are up to, and then time and again, the international level says, they're not doing a good enough job, we must intervene. Again, some practical examples of how this is played out. You go to Ituri province in northeastern Congo. The ICC's first ever cases came from Ituri. Thomas Lubanga, Jermaine Katunga, Matthew Ngujolo. At the time that the ICC began its investigations in Ituri, those exact suspects were being investigated by the domestic courts. The domestic courts in Ituri had gone through a very lengthy reform process funded by the European Commission. To cut a very long, complicated story short, the ICC stole those cases from under the noses of the domestic courts, much to the fury of Ituri lawyers and judges, who said, but we're doing these cases, and we're doing them in a way that is being prescribed by the international community. And now we're being told that we're not up to scratch. And these suspects are now being whisked off to The Hague. Now that was hugely damaging to a newly reformed judiciary that said these cases were our opportunity to show our local communities that we can do these kinds of cases. Our work is being drastically undermined by the theft by the ICC. Now that theft of those 3 cases that ended up in The Hague was only possible because of a close relationship between the ICC and Kabila's government in Kinshasa. So this is a story about international power, but it's also a story of the weddedness of international power to domestic political power. Because Kabila's calculation, and it's a very important one, is that he felt that he could control the ICC much more effectively than he could control his newly reformed judiciary in Ituri. His concern was this newly reformed court system, if these trials go ahead in those courtrooms, there's no telling what's going to come out in the open, including the role of Kabila's government and the Congolese armed forces in collaborating with at least 2 of the rebel groups that were going to be dealt with through those cases. Whereas Kabila knew that his government had already constrained the behaviour of ICC investigators. They didn't know the context. He had more faith in his ability to control the international level than to manipulate the domestic, and so he collaborated actively with the ICC Office of the Prosecutor in these cases ending up in The Hague. So why is that important? It's important because what we have seen time and again, through the ICC, through the ICTR, because of this distance mentality, has been the systematic undercutting of domestic institutions and the weakening of domestic agency. It should also be said that the European Union is completely complicit in this. Having funded the reform process in Ituri, the EU then completely backed the ICC in dealing with those cases, almost killing its own baby. We reform these courts, but we're going to turn a blind eye when the international community won't allow these courts to deal with these cases. It's a big problem. The systematic undermining of domestic agency. Finally, a third major problem that comes out of distance in the Great Lakes. And actually, it's not just about the Great Lakes, it's broader than that. Is a constant sense from the international criminal legal community of how dare you criticise us. Because embedded in the philosophy and the practice of distance is a sense of the superiority at the international level. A real sense of the international, again, being technically, philosophically, politically superior to the domestic. It's there from the beginning. As a result, I just want to know, is there a more sensitive, thin-skinned community than international criminal lawyers? And again, I say this as a political scientist, by goodness. Some of you are on Twitter, right? The ICC and these other institutions, a lot of their own personnel are on Twitter, but they're careful because they're not allowed to say certain things. But they have a ruck of supporters, right? Loud, frothing at the mouth, angry, very angry. God help you if you're getting embroiled in these debates with these folks, which I do. Yeah. And my wife often says to me, put the phone down. There's no need. It's 4 a.m. Your children are screaming. Get off the phone. She's right. She's right. She's clear. You know, Tyson was there. I took my book to The Hague. I launched this thing that evening. But earlier in the day, I think Ty saw me directly after this. I was a bit battered and bruised. I made the mistake of agreeing to do a thing that academics are supposed to do, which is, take your works back to the communities where you did your research. Now, in my head, that meant northern Uganda, where Keti's from, it meant Ituri, it meant coming back to Rwanda, but it also meant The Hague. Yes. So I had a round table with the prosecutor's office. This was good. That's 3 hours of my life I'll never get back. They were angry. One of the senior investigators, amazing, turned up. He had produced a compendium of my tweets about the ICC going back like 7 years with things circled. I was like, no wonder your cases are collapsing. You're spending all your time following my social media stuff. You need more time in Ituri. It's the man. They were touchy. Now, fair enough, right? I say some fairly nasty things about the court in the book. It's fair game, right? It's game on. But I was struck by the unwillingness to engage critically. The imperviousness to criticism. Because there was a real sense of the inherent virtue of international criminal law. We're on the side of the angels. We've been fighting these virtuous fights for decades. Who are you, academic punk, to come along with your little footnotes and tell us that the great fight we've been fighting hasn't been worth it? Interesting. We're bringing civilization to the savages. Mikhail Matua was onto this stuff years ago, before it was common, before it was popular. Mikhail was like, that's what these people think they're doing. It's part of the reason why they don't like the criticism. There's this myth of the continuity from Nuremberg. great things invented at the end of the Second World War. Then ICL goes quiet for 20, 30 years, and now look, we're back. We've got the global permanent ICC, and we're doing wonderful things. We're changing the nature of international politics. That was one of Ocampo's early claims. And then what you get is this amazing triumphalism of ICL. I mean, the key moments have been the 10th, the 15th, the 20th anniversaries of the ICC, startling anthropological events. Some of you, much closer to The Hague than I've been, have had the misfortune to watch these things firsthand. I've just watched them kind of mouth open from a distance. They always coincide with massive ICC failures. Cases in Kenyatta involving the killing of numerous prosecution and defence witnesses, the collapse of the Bagbo and the Bemba cases. It's not that they were found innocent, it was the cases collapsed because the investigations were so shoddy. Because if you're parachuting in foreign investigators for only 10 days at a time into places they've never been to before, that's what's going to happen, right? And some more enlightened members of the Bagbo and Bemba prosecution teams along the way were saying to any researcher who would listen, we're in trouble here. We've been cutting corners, relying on intermediaries, relying on local media and human rights reports. It doesn't look like a serious investigation, but we're going to put it in front of the judges anyway. So they knew. They knew there was trouble. But what you get at these anniversaries is this sense of the majesty of the whole enterprise, of the industry, as Ty said. Totally devoid or detached from the reality of what the court's actually been doing on the ground, the damage that it's done to the places in question. I have other things to say about that, but time is short, so let me wrap up. International criminal law has become a hegemonic industry. There's some great work in the African politics literature about the tendency of liberalism to want to dominate. Tom Young, Chilean Bembe and others. It's built into liberalism. It sounds tolerant and cosmopolitan, but it actually wants to be in charge. You're going to be tolerated on our terms, and international criminal law has done that in spades. And as a result, disempowering attempts at creative domestic remedies. The Great Lakes, however, has delivered massive pushback to this enterprise. I promised I was going to talk about Uganda, and I haven't. There's so many examples from Uganda of the same stuff. Actors at all levels of Rwandan, Ugandan and Congolese societies saying there are different ways to respond to mass atrocity, and we're going to do this anyway. And we're going to fight against international actors telling us that we have to do it differently. Invariably, I come back to Gacaca, which I think has been one of the most important interventions in Rwanda's post-genocide recovery. It's not the only one. You're going to see lots of others this week. I'm writing a book at the moment on Rwanda's welfare system, the importance of tackling socioeconomic inequality and how that intersects with things like Gacaca. So it's not Gacaca on its own, it's Gacaca embedded with other interventions. But Gacaca has been absolutely central to the Rwanda that you find today. To my mind, it's the most important reason that when I go and see these convicted perpetrators in the Bugesera, they have very, I wouldn't say harmonious, but they have functional, peaceful, productive relationships with the genocide survivors who live in those communities. And when I interview the survivors, they tell the same story. It's tense, we have huge historical trauma that we continue to live with on a daily basis, but our communities work. And we can work together on the farms in a productive fashion. Gacaca is absolutely central to that, but it wouldn't have happened if the ICL community had had its way. The final thing that I'm going to say, coming back to this idea of export, which I wrote in my notes as Tice was speaking, was very useful. Rwanda now, having never really been a net importer of justice, has become an exporter. And one of the places that we can look at for the resonance of the Rwandan experience and the Gacaca experience is Colombia. And I know we've got at least one person from that. I got invited to go to Bogota. I've never been to Latin America the first time. I got invited to Bogota during the Havana peace talks. There were, 7 government ministries that all had transitional justice departments. You've never seen so much transitional justice saturation anywhere in the world. And they said, well, what we want is, we want you to come and give a series of lectures on transitional justice lessons from Central Africa. So, I gave 6 or 7 talks, and every single talk, I started with the same thing, which was, I have no idea, I know nothing about Colombia, so I have no idea if anything I'm going to say to you is at all relevant for your context. But let me present this stuff, and then you tell me whether any of this resonates. But one of the things that I did try to impress in these talks was, if you look at the experience of this region, perhaps most magnified in the Gacaca experience, there has been this attitude of doing what the local context demanded and being strong in responding to international prescriptions. So if you take nothing else away from these presentations, I said, take away the idea that then you have more latitude than you are going to be told. Because of the Rome Statute, because of the power of the international human rights community, you will be told that you have to do it like this. But these countries in Central Africa, in varying degrees, have said it doesn't have to be like that. Now that seemed to resonate. Not so much even the details of it, except that, as time has gone on, it wasn't because of me, but it was because there were Colombian delegations that came to Kigali and vice versa. A little bit of Gacaca has smuggled its way into the justice and peace law in Colombia, but in a very important way, which is when it comes to sentencing convicted criminals. The Colombians had the kind of task that Uganda faced, which is you're going to hold peace talks between a government and a rebel group, with the ICC hovering above you, and you're being told that you have to prosecute all levels of actors, but particularly the top brass. But if you push that too hard, the rebels are going to walk away from the talks. The LRA did it in the Juba process. The FARC threatened to do it in Havana. So you've got to get creative with your conceptions of accountability and justice. Things that was available to various Colombian delegations in Havana was a sense, because of Gacaca, that you can convict, and then you can get creative at the sentencing end of things. And it wasn't just about Gacaca, it's about a million other influences as well, but Rwanda was there. And a whole range of mediators who were involved in Colombia, who are now writing their stories about what happened in that peace process, talk about the Rwandan influence. And so what you then get is this really interesting Colombian innovation around deprivation of liberty, but that is short of imprisonment. So rebel leaders get convicted of crimes, and then they can live at large, but within these kind of confined communities, if I'm not making too much of a pastiche of this. So it's creative, right? The punishment's there. There's a sense of a sentence for the crime, but it was delivered in a way that was palatable to the folk. And then the other bit, which is lifted, I think, pretty directly from the Gacaca experience, is a question of where community service fits into all of this. So can you take convicted perpetrators and put them back in the community, but make them work for the benefit of the community? It's punitive, but it's practical, and it has these very tangible benefits for genocide survivors and others dealing with the legacies of the past. So this Gacaca experience that was so pilloried by the international critics now is becoming an inspiration for context around the world. And Colombia won't be the last one. We're going to see this time and again. So that's why it's so important that we're having these discussions in Kigali. This is a totally different conversation if we have it in Toronto or London or Amsterdam or wherever. This is such an opportunity, to use Sarah's word from this morning, to think about what the big theoretical debates we have about ICL look like when you put it into this direct context. It forces us to ask different questions. It forces us to think very, very seriously about local consequences of different justice decisions. And it changes our frameworks, builds different kinds of relationships, and forces us to have different kinds of debates. So I applaud the organising committee for taking an event that could so easily have been somewhere else and putting it here and getting us to think about these things in this place. Thank you.
I have a question about something that I've come across reading about histories of transitional justice, and it's this kind of theme of morality being used as an excuse to deploy international law, and then detachment and distance and neutrality being used in the deployment of international law. And I've seen, there are very valid critiques of both, And then, interestingly, you often also see international legal actors criticizing local justice actors for the opposite, right? For deploying law too neutrally, allowing impunity, and then over-moralizing the actual use of the law itself. And so I really struggle to kind of reconcile those two things and the critiques of both, and I would just be really interested to hear your reflections on those.
I've been, struggling with this for a long time. I'm from the Ivory Coast, so, a lot of things are also personal, right? But I've been struggling with this sort of problematic track record of various institutions. I mean, I'm thinking of them as like official narrative forming institutions, such as Amnesty, International Human Rights Watch, and various authoritative journalistic, news outlets. And how they, there are all kinds of blunders, there are all kinds of issues, but somehow they retain that position of authority. And I'm thinking about how that links to a question of audience, as in, who they are accountable to, who they are speaking to, and how, the ICC, more formal international organizations are very much, part of that sort of group, including the ICC. And, I remember watching the Bago Big D case, I was obsessing over that. But seeing, there were lots of protests throughout the many years that they were at the ICC. And A, they were not mediatized, B, they were not engaged, and they're still not engaged in most of the academic literature. And so I'm wondering, this question of audience and who is picked, is picked out as being, the sort of local. I mean, I could go on about like my problems with this idea of the local, but anyway, we can talk about that later. But yeah, I just want to hear your thoughts on those two things. Hopefully, I've made sense.
Thank you, Philip, for a wonderful presentation. I've been struggling myself with the other night, Kamari presented myself as a believer, a transitional justice believer, and I think this is the word of this species, because I've been struggling myself to think if I'm a believer or not, and some questions that have popped up this morning made me question myself if I'm a believer, and actually that question of how transitional justice can be a new way of colonialism is just stuck in my head. And I'm so glad you brought up the Colombian case, because I think that we have been able to be creative first because we don't frame the system as an international system, but also because we have been having this international budget or this international support. But I've seen, because I worked with the Special Jurisdiction for Peace, and I've seen how our creative sense has been limited because, there's no budget for that. There's no budget for symbolic things. There's no budget for bringing indigenous communities in this because there's no money. So I'm just struggling how can the local system disengage from this international dominance if the system owes them so much in terms of the construction of the whole system, but especially in terms of the funding of the system and its operation. And the question is, of course, not a financial question, but a matter of how can local justice systems can disengage of this international management when its functioning is so dependent of that budget.
Said in the presentation are things that I totally believe in. I'll give an example when I worked at the International Criminal Court as a visiting professional, and we were working on doing a common case in Northern Uganda, and the news from the grassroots was coming that wow, the people prosecuting was totally white. I think we were 2 or 3 blacks on that team, like 11. And the response within the team was, you are going to wait eternity before you get people of color that will prosecute you. That kind of ceremony where you think that we're superior, which is spoken about. I don't have a problem with that. I want also to think some of the issues. And when you're talking about Kenya, what came to my mind was the fact that the reason why the investigation, prosecution in Kenya collapsed was because the investigators, apart from not knowing the local areas, whatever, was the fact that the state itself had control, effective control, over all the witnesses, all the people that the ICC could reach out to. And that undermines the prospect of the West believing that Africa can do justice when the power that we can easily influence it. Judiciary easily influence access to witnesses, easily influence, evidence gathering, data collection, and so on and so forth. So that's a real issue that's there, which I think you kind of in your speech skip over and say that, well, these are good things. Again, what can we learn from that? That's one aspect of it. And then number two, you spoke about the character. I like those ideas. But I was thinking from this angle of, can we have an hybrid justice where we combine local conception of justice, like Gakaka, customary norms, with this same international justice norms that has been, well, not whatever, but at least it's there that we can break. Instead of moving from totally into local and leaving the international conception of justice, again, it doesn't have to look like that. That's number two. And then number three is something that you speak about in your presentation, and this is something I grapple with, which is the fact that Africans are complicit in that demonization of international law. You need to go to ESP conferences. African delegates, we enormous power in the selection of registrar, in the selection of judges, and they go there every year to win this power. And in fact, if you look at the international criminal law, you know that all the cases of Africa, when you talk about it, I was thinking, it was the same African state that took it to the ICC, where you said back by EU. But again, the point I'm making here is that African nations are also complicit in this. We look at Maputo, what's it called, protocol. What's the reaction? What's the last 10 years? What has happened to it? What have African nations done? So what I'm thinking is that, well, we need localized justice. We need that. We also need this kind of way of building support across the board, not just that we focus on that local system, without looking at the weaknesses in our local system that makes the position of international crime not to be possible or not to be very effective. Thank you.
Yeah. Great. Okay. I'll find the button. Knowing we've got lunch and a bus, I'm going to be brief. So, first question about morality. I think there's a huge amount of morality that's smuggled into international criminal law. So, in my book, I find I have to excavate the concept of distance because it's very rare that any actor in the system talks explicitly in those terms. They prefer to talk about what they're doing in a whole range of other terms. Deterrence, contribution to peace, relations between nations, mending broken societies, it's that sort of stuff. So there's morality all the way through it. But when you dig a little bit deeper, and especially when you connect that to the practice of these institutions, that's where I think the distance really comes in. But I think your instinct is absolutely right. The morality of all of this is there in the minds of the practitioners there. But I thought your second point was particularly important, which is the tendency of the international realm is to criticize the romanticization of the domestic or the local. And the terms matter here, but we don't really have the time for all the necessary semantic arguments. So there's always a sense of, look, the local, the domestic is patriarchal, it's run by old men, it can't deal with sexual violence, it's out of touch with the youth. The list of local problems is long. And some of that's true. So I'm certainly not arguing for a romanticization of the local. What I'm asking for is a more equal conversation about local spaces and international, because I think the much greater romanticization that we deal with is the romanticization of the international. The myth that has been constructed about this neutral, politically insulated space is a furphy. And in fact, that space is as replete of all the criticisms attached to the local as you could ever ask for. It is also patriarchal, run by old men, disenfranchising of the youth, struggles with sexual violence cases, etc., etc., etc. So we have to have critical discussions about all of these practices. It's just that over time, the international has become more insulated from criticism. We've got 30 years of critique of community-based or national institutions. We know that stuff. We have to turn our focus now to the level that has been getting away with it for too long. And I think to a certain extent, that's what I'm trying to do here. Then a question about these official sort of narrative constructing institutions was a great phrase, by the way. Look, I think your instinct's absolutely right there. It's who not just the courts and the tribunals, but the epistemic communities around them, the human rights groups, the media practitioners, who do they think they're ultimately speaking to, and who do they think all of this is for? And I think there's some really problematic stuff going on here. It would be too simplistic to say that it's only about an international audience, but I do think that's the primary audience. And that's why spending time in The Hague and Arusha is important. Getting to know those communities and what makes them tick is crucial. It's also about understanding where their money comes from. And we cannot talk about justice at any level, and this is great because Laura's raised this issue in the Colombian context. You have to look at funding. And don't tell me that the ICC is not beholden to its donors. You know, one of the things that really shook, particularly the prosecutor's office in The Hague, was when the British government started to say, we're not so keen on international justice. This was the discourse 3 years ago, right, in London, in Westminster. Post-Brexit, where everything was about national sovereignty, there was this real suspicion of the ICC. Also, the ICC was hovering around British atrocities in Iraq and Afghanistan. So suddenly you're getting this real anti-ICC rhetoric coming out of one of the ICC's major donors and providers of its senior personnel. So what do you then get from Bensouda is you get practical moves to calm the horses in Westminster. We're not dealing with Iraq. That's what the domestic institutions are doing. Despite the fact that London is doing nothing about crimes committed in Iraq. I mean, my goodness, if the Congolese government did what the UK government is doing on Iraq, the whole pile of bricks of the international community would come crashing down on us. It's massive double standards. But Bensouda panicked. We can't lose the Brits. So they worry about the donors. They worry about the international audience. We have to be attuned to that stuff. There's more to say about that. You've got to bust the couch. Laurie, I like this transitional justice believer. I like the honesty. These discussions should always start with a confession. I'm not Catholic, but the Catholics have got a few things right? Get it out in the open. It's the spirit of Gachacha. Get it out there. So yes, you talked about domestic budgets and domestic priorities. I think that is important. We have to think about power, but we have to think about money in the context of these things. Because that stuff really, really counts. But I was particularly struck by your comment about how the Colombian domestic system, the legal system, the political system, dealt with the international level. Because of its entanglement with that level, and to a certain extent its reliance on some aspects of it. I was struck by this, watching Colombia as a total non-specialist, was how much more freedom the Colombian system got to think about those creative responses than, say, the Ugandan government did, or Ugandan actors did in the context of the Juba peace talks. And to be honest, I think there's a simple reason why. It's because deep within the office of the prosecutor, particularly under Ocampo, but I think it's continued, is a sense that Colombia is a sophisticated legal community that can be trusted to deal with this stuff. The deep-seated prejudice institutionally about a place like Congo or Uganda is these guys can't do it. It's racist. Yeah. And it was useful for Colombia because they can, with the ICC hovering around with a preliminary investigation, why have we not seen the ICC intervene in a way that they did in a comparable situation in Uganda? At least part of it is a belief in the robustness of the Colombian system, which was a liberty that was never afforded to the Ugandan system. So there's a massive double standard here. There's a whole Latin America versus Africa viewpoint that has to come into our discussions about the ICC. So that's at least part of it. And also many Colombian diplomats were just much more au fait at navigating at that level. They knew these people. They could speak their language. And they were able to buy themselves breathing space in Havana because of that knowledge of that realm. And then finally, Io. Yeah, this is good. I mean, this is where the rubber hits the road, right? This is the tricky stuff. So, I come up here and I build an argument about the problems at the international level and the need for much greater space for domestic decision making. But you quite rightly then say, are you talking about states? Because states have done horrific things. You name the Kenya case. Absolutely right. It's the Kenyan state that killed these witnesses on the ground. They're able to do so because the ICC leaves a very easy evidence trail. So the state knows exactly who they have to follow. So the ICC is complicit in this, but it's ultimately the states. Or, as I said in my presentation, one of the reasons why the ICC could do what it did in places like Uganda, riding roughshod over a peace process, or in Ituri, riding roughshod over a domestic justice process, is because it was acting with the complicity of the domestic government. So African governments are a massive part of the problem here. But why do we see such a close relationship, a cozy relationship between African states and the ICC? It's because these states have worked out that you can manipulate this court incredibly